law of sedition, which is often referred to as Rajdroh in Hindi, had been before the Supreme Court for a pretty long time. The question remains to be the constitutional validity of Section 124A of the Indian Penal Code. This is a pre-constitutional principle that has been existing in the law itself, a part of the IPC, basically towards an offence that is committed against the government or against the state as per the current reading. Now, the law had been in abeyance for quite a long time, and today the Supreme Court has referred the issue of the constitutional validity of Section 124A, that is the Sedition Law, to a larger bench of not less than 5 judges. Now, the major contention that why this reference has been made is that the petitioners have constantly argued that the whole interpretation of the Kedar Nath Singh judgment of 1962, wherein the Constitution bench had upheld the 124A, the provisions of the Sedition Law, has very categorically noted that this is a dissatisfaction against the state and not the government. Now, this is the exact challenge before the constitutional validity of the same. However, the central government had constantly been opposing a reference or an adjudication on this particular issue, saying that they have brought in the Bharatiya Nyaya Sanhita, that is the new penal code in the country, and for that matter, sedition finds its way, though it has not been named, but the law has been looked into by the government. In fact, the Solicitor General of India, Mr. Tushar Mehta, today while the arguments were being addressed on these petitions challenging the constitutional validity of the sedition law, very clearly stated that though the previous governments have called sedition law a draconian one, they had missed the chance to change or rectify it, and when the government is doing it at this point of time, they are correcting it, then it should be allowed to do so, and hence a reference at this point of time or any kind of adjudication by the court at this point of time is something that should not happen. However, the Supreme Court considered all of the sides, they considered the side of the petitioner, the side of the government itself, and declined the government's request to stay it, and has very clearly referred it to a bench which would constitute for at least 5 judges in nature. Now, remember that the Kedar Nath Singh judgment of the 1962 was also a 5 judges bench which actually upheld the constitutional validity of Section 124A, and in fact the Law Commission of India, which had recently given out its report, had said that sedition is a law that is needed. Seeing the prevalent situation in the states of Punjab and various other states, sedition is a law that should be must. However, the rigors of the law have been improved. There have been mechanisms that have been inserted and insulated in this particular proviso in order to make it a better law and to prevent any kind of a misuse of this law. In fact, the central government had constantly argued before the Supreme Court also on various occasions that any kind of a law, though there might be a misuse of that, there might be abuse of that taking place, but though it can be improved, but this misuse or sheer misuse of a minimal misuse of a particular law cannot be a ground to quash or to finish that particular law. So how would the Supreme Court be dealing it? Which would be the judges that would be hearing this particular matter? All these questions are to be answered with time, but at this point of time, this big order coming in from the topmost court of the country, very clearly referring it to a larger bench of at least 5 judges, and in fact declining the government's request to stay any kind of adjudication on this particular issue.